Hi, I'm Lucy Harvey. I'm conducting an oral history for the Securities and Exchange Commission Historical Society. Today I'm talking with James R. Doty, who was General Counsel of the SEC from 1990 to 1992, and then Chairman of the Public Company Accounting Oversight Board from 2008 to 2011. Today is Tuesday, April 6th, 2021, in the COVID time of the plague. Mr. Chairman, thank you so much for joining me.
A pleasure, Lucy.
Excellent. I'd like to start our talk today with a little background on you and just a little overview of your education. You are Texas born and bred, correct?
Correct.
And you started your college career at Rice?
Yes.
And then tell me where you went from there.
I left Rice and went up to Oxford in 1962, came down from Oxford in 1964, began pursuing a PhD in modern European history at Harvard, and finished my orals, became ABD, as we say. And many of my friends having gone to law school, and I having spent a lot of time with the European history, studying the lives of lawyers and thinking that lawyers had exciting lives in the 19th century, I decided to go to law school, and I did. And went to the Yale Law School, came out in 1969, went back to Houston, joined the law firm of Baker Botts in Houston.
And then you had a brief little interlude at the SEC. Tell us about that.
It was one of the most rewarding experiences of one's life. Several people described it to me as the best job in Washington. Some of my predecessors in the office and others. I had had the good fortune to meet Richard C. Breeden. At the time, I was back at the firm and had moved up here to Washington. Richard became chairman of the SEC after the election of George H.W. Bush and a brief term in the White House as a special issues advisor. And I then went over there to meet him one evening in October to meet him and some of the staff. And it turned out we had selected the day of the market break in Wall Street. So I ended up staying until 2 o'clock in the morning, met a lot of the senior staff, Richard Ketchum, Linda Quinn, Dan Gelzer, all of whom became close associates and friends later. Richard invited me to join as soon as April of 1990 and stayed through 1992, left in January of 93. And really felt it was one of the experiences that you were fortunate to have. I learned a lot, and I do not believe I could have been chairman of the PCAOB without what I learned at the SEC.
Now, how was it that you came to represent the PCAOB during their Supreme Court challenge?
We had just brought to the firm in Washington two talented young alumni of the Solicitor General's office, Jeffrey Lamkin and Robert Cry. We had a young appellate practice. I thought this was the case that we should have. It was a wonderful case to be litigated and to take an appeal on. And it turned out that it went all the way to the Supreme Court. And we had the chance to take the case, and we did. Lamkin and Fry had analyzed it carefully, and I was unduly optimistic about the results. Being an SEC former general counsel, I thought it was obvious that the PCAOB had the authority, that Congress had performed a proper delegation, and a young lawyer in a young judge in the DC Circuit, Judge Kavanaugh, wrote a dissent, which raised issues that were worthy of a Supreme Court opinion. And so we eventually went all the way up to the Supreme Court. And it was far from an easy prediction, but I had been overconfident, I think, that it would be a straightforward case for the court. It raised many of the issues that are now there before the court and have been there with the Consumer Finance Protection Bureau and will be there again with other federal agencies. And it's an opinion in which Chief Justice Souter, or rather Justice Souter, writing for the court, found that or achieved a majority to uphold the authority of the PCAOB while excising the removal for cause qualification for board members. So it established, I think, a very strong precedent for what the courts will be looking at when Congress performs future delegations in this area.
What was your path to becoming chairman of the PCAOB then, when you had been on the outside?
Well, I would of course like to think that the office sought the man, but I can't be sure of that. I felt that it was obviously an important agency, and having met and having known members of the board, Charles Niemeyer, Stephen Harris, Dan Gelser, it was clear to me that it was a very worthwhile coda to a law career. And I think Mary Shapiro and David Becker had been good friends and associates. I had worked with Mary when she was a commissioner. She was chair. David was her general counsel. And as far as I know, they came to me and asked me, would I be interested? And I said, yes, I would be interested. And I was. And that's what led to my appointment.
Okay. You have said throughout your tenure at the PCAOB that the audit is the linchpin of the financial markets. So how was it that you came to that conclusion?
Practice, my own experience in practice, a long association with lawyers who understood the importance of the audit in financial accounting and financial reporting, and who were supportive of the independence of auditors. I had a sufficient experience at the SEC to see how significant the audit was in the underpinnings of what became financial disclosure. And then, of course, we had just had Enron, WorldCom, and Delphi. So suddenly you had a focus on Main Street financial reporting, in which the failures of the audit had been at the core of the financial problem, of the financial reporting problem, and the collapse of very important issues. It was clear that the PCAOB, being created by Congress in that atmosphere, was going to have challenges that would, year after year, would recur with different emphasis, but nevertheless the same questions of independence, objectivity, skepticism, the skill and the craft of the auditors on the account, and very important for the whole process, the engagement partner and the managers, the senior members of the team, and the tone from the top that was being set by the firm. And so this was clear to me by the time I got to the PCAOB.
What were your priorities, and how did you set them when you first arrived at the PCAOB?
A lot of things had begun to move. Change was in the air. I had spent time with Rod Hills and Paul Volcker and some other very, very knowledgeable people in the context of the American Assembly projects on the future of the audit profession. The commission the special task force that had been established by the White House and coming forward with a proposal that the auditor sign the audit opinion had become a point of some contention. We were just beginning to see how important, I think, the foreign audit was, the participation of other firms. So for my own development of the priorities of what the audit profession needed to do, there was an initial bias toward better disclosure, more transparency. Much of what I had heard throughout my career and what I heard at the American Assembly project was concern over expectations, the expectation gap, and what Rod Hills used to call the brittle illusion of exactitude. And clearly the public in Enron and in WorldCom, these other financial problems, including the 2008 financial problems on Wall Street, the public had trouble seeing what the audit really was and what it was supposed to be. And it was, in my view, it was important that the PCAOB start addressing that issue. For me, the most important first step was what we came to call the transparency initiative. Identification of the managing part of the audit and the engagement partner and the manager would seem to be a good idea. Identification of the other firms participating in the audit would be a good idea. And we came to that through some compromises. The firms reacted negatively and strongly to the idea of signing the audit opinion. As lawyers, we were accustomed to signing on behalf of our firm, but the audit profession saw this as being a risk that they shouldn't have to take. We moved towards some compromise positions. Eventually, the question would be whether the engagement partner would be part of a disclosure in a filed document under Section 18. That led to reiterations and reproposals, but we got to Form AP and the disclosure in a PCAOB form of the engagement partner, and frankly, a fair amount of other very useful information for each public audit. We also included disclosure of other participating firms because it became clear in the process of looking at this change, which had been a concept release by the time I got there to have the partners sign. It became clear in this process that there was not much understood by some people, some of them quite knowledgeable, as to how much the participation of foreign firms was behind the screen, was not transparent. So we moved into that area, and with it, a lot of work having been done on how to modernize the audit reporting model. We came to a formulation of how we would do an expansion and an amplification of the disclosure in the reporting model. There were options there. We could have gone toward a report on an audit of MD&A. There were discussions about that, but I think we came to the right result, which is to require the auditor to speak to the critical audit matters, the matters that were particularly difficult, that involved subjective judgments, and that were material, and that were communicated or required to be communicated to the audit committee. So that resulted in the audit standard that has now produced 2 seasons of critical audit matters, with I think some very good results, not only for the public reading of the report, but also the improvement of internal controls as the audit progresses, as the audit moves through the process. So one of the things that we wanted were disclosures that would have a beneficial effect not only for the public reading, but also on the conduct of the audit. And I think that was achieved with the work of very many hard people at the staff, by the way.
No, absolutely. So auditor's reporting model was very big. development for you. You also describe your proposals for auditor independence and the reaction to your efforts there.
Yes. Well, as I said, there were strong winds of change, and among those proposals and winds of change was a very strong opinion in some sections that we should do something about the auditor's term. The Act, Sarbanes-Oxley, of course, requires the rotation of the engagement partner, but it was viewed as being a faute de mieux, a partial remedy. That in fact, in the era or in the reality of the client-payer model, we needed to consider whether or not engagement should be limited, whether issuers should not be required to put out for bid the audit. This was probably the most controversial event of the period of the entire time that I was there. Interest in this had been building. There were people who felt it was essential to do it, and there were others who were equally committed that if you did it, it was the end of the independent audit profession. And this is, I'm not glossing. This is in fact what we were warned and told, that if we did it, the independent audit profession would disintegrate. Europe was headed toward doing it. We knew they were going to do it. It was clear they were going to do it. And so we chose instead to put out a concept release and to ask for comment. We also held hearings. Part of the process revealed that in fact there were various opinions on the utility and the risks or the benefits of requiring a change in the audit firm every X number of years, but there had not been a disciplined, rigorous look at that we could find. And so we held hearings. We called in members of the audit firms, academics, investors. We called in eminent public figures such as Harold Williams and Paul Volcker and Rod Hills. We called a lot of people to come and talk to us about what they thought of this kind of change. It became clear, and in fact, from the concept release, we had indicated that the European approach of a change of the auditors every 6 years did not appeal, that we were really interested in what people thought about terms that extended beyond 6 years, perhaps 10 years, and perhaps with an opportunity to renew. That actually, I think, had an effect on the way the Europeans eventually went with their rule. We were moving along nicely with the development of a record, and a record which is there, by the way, and which exists for anyone who wants to look at this in the future. When Congress took a hand and the House of Representatives passed a bill which forbade us from doing this, and that forbade us from either imposing term limits on the audit or requiring an audit of MD&A. And so we, of course, always listened to Congress, and we moved along. We had other things to do that we thought we could accomplish that were very important, and that we did. But I think the discussion and the debate on term limits of the engagement frames the limits of what is possible now. It is the ultimate way of limiting the effectiveness or the influence of the client-payer model. And for that reason, it may be one of the most important results for the auditing profession to come to in the fullness of time, because I think what we are seeing is increasing dissatisfaction with the fruits of the client-payer model, and I don't think we can foresee the government taking over the audit of public companies. What you're now seeing in the UK, for example, is the requirement of a second audit to balance to counterbalance the effect of the large firm that has the major audit. These are all difficult, and none of them are really satisfactory answers. There is no magic solution, in my view, to the client payer model. The preservation of an independent, non-governmental audit is an important part of the free enterprise system, and therefore, what do you need? You need a strong, independent public company accounting oversight board. You need inspections. You need what I was told from the day that I began to be interested in this organization. You need to have an organization that has expertise, that can push the firms to increase the quality of their audits, keep the pressure on them to do the right thing, and I believe that firmly, that the PCAOB is absolutely critical to maintaining the quality of the audit and maintaining the independence of the audit function from a governmental regime. It's going to be interesting to see what happens in Europe in this regard. But I would just note that the firms, I think, to some extent, have gotten religion about this. They would like the PCAOB to be tractable, to be more of a cheerleader, less of a critic. And in my view, at the time I came to the board, the two most important things were, first, to make the PCAOB respected by the firms, and to make the staff of the inspection division respected by the firms, and to create the morale within the organization that we were doing important work, and that this was an organization that had a strong common sense of mission. If that exists at the PCAOB, the firms will listen, and the firms will, in fact, seek to improve their audit, and that's what's happened. I think that's what happened. In the 7 years, short of 7 years I was there, you could see the firm's objections to the inspection findings plummet, go down. The firms began to take the view that we will remediate. We will do what is necessary to make the board satisfied that we are addressing our audit problems seriously. That oversight by the PCAOB is essential. If you look at what others see abroad in the PCAOB, you can see how this has developed. Sir John Kingman, after the Carillion fiascos in Great Britain, came over, he talked to many people here, including the firms, went back and wrote a report that said we need in the UK an oversight body that enjoys the independence and the authority that the PCAOB enjoys in the United States. And that, of course, that ties to the independent funding of the organization and to its ability to conduct its inspections without influence by the street or the firms. Extremely important.
I'm going to jump in here and ask you about auditor skepticism, because you focused on that during your entire tenure. And you said, skepticism is a state of mind, objectivity, a silent success. Their absence is rarely documented and can be particularly difficult to detect. So that was a very big focus of yours, auditor skepticism. How did that come to be? It
arose in the context of the financial collapses that we had seen, the Main Street collapses. The Division of Inspections and Registration looks hard at the performance of an engagement team. We saw examples in which either the opportunities for fraud were not properly scoped into the audit, or having been scoped in, would be abandoned under the pressures of time of completion of the audit. These are the enemies of skepticism, looking for disconfirming information is hard, and the auditor to do that runs the risk of rubbing management and the middle management the wrong way, but it's essential. We know from psychology that we would prefer to believe we would prefer to find evidence that reinforces what we already believe. This is not heretical. In fact, we would be naive to think that when being hired by and paid by the management and needing to preserve the relationship of a major client, the auditors don't, in fact, want to find that the issuer's financial reporting is sustained by the facts, by the books and records of the company properly kept. To press that point home and to press management on that point, and to in fact find areas where it fails, is a very hard thing. And it requires an attitude of a zeal, a sense of commitment to your profession that transcends, goes beyond the limits of the particular engagement. You are, as an auditor, as an engagement partner or a manager or a young auditor, you carry the firm's reputation with you in the audit. It's a very hard thing for a young auditor to bring to the attention of a manager, and for the manager to take up the line, and for the engagement partner to take into the C-suite or the boardroom the view that the books have not been properly kept. But unless the auditor looks for it, unless the auditor is thinking we have got to find it, we've got to test the systems. These are now largely system-based records, and so the auditors have to be able to be forthright in testing those systems, especially among companies that are global, that have many business locations, that have grown by acquisitions rapidly in the past. There are, in other words, red flags. There are circumstances of the audit issue, of the auditee, of the issuer, that require the auditor to scope in the real risk of fraud. At times, we hear the members of the audit profession saying we are not obliged to look for or to find fraud. They do themselves a disservice, as they did themselves a disservice by saying we don't want you to know who our engagement partner is, or we don't want you to know how many other firms participated in the audit. That is not good for confidence in the audit, and for them to say we don't look for fraud is also not consistent with the auditing standards, with their responsibility, and it is not consistent with good audit practice. So skepticism is what drives that. Without a streak of skepticism, perhaps one is not suited to be an auditor or a lawyer if you have no instinct for skepticism about what you're being told.
In 2008, the discovery of the Bernard Madoff Ponzi scheme, $65 billion Ponzi scheme, gave the PCAOB the authority over the audit of non-public broker-dealers audits. And so what did the PCAOB, that was just as you were coming on, the PCAOB had this huge new authority, and were they up to the task, and what did they need to do to get that program up and running?
Of course, they were up to the task. The PCAOB is always up to the task. They knew audits of broker dealers. They had audited major financial service holding companies, so they knew something about how the brokerage industry was structured and what the audits looked like under SEC accounting standards. To produce the accounting statements the SEC required. The accounting statements were required by the Commission, and the auditing standards followed those. The board is directed by the statute, if it chooses to inspect the audits of broker dealers, to go do that. If it chooses to consider different rules or different schedules, it can choose to institute programs, schedules for the brokerage industry, depending on the complexity of the brokerage business. Congress essentially tossed to the PCAOB the most difficult questions, which were, how is an industry as diverse and as fragmented with the ease of entry of the brokerage industry and with as many different business patterns, how is the audit best imposed on that business model? And the Commission, or the PCAOB, did immediately what it should have done. I think we established a task force. Helen Munter and Bob Madej went out to collect the information about different strata, different forms of business in the brokerage industry that we would need to be able to evaluate the other questions that Congress had given us, which is what should be the schedule for audits, what should be the program for audits, and what kind of exemptions, if any, should be granted. These were not simple questions. They required looking at a great diversity of firms. But the PCAOB did the one thing which Congress said they wanted us to do. We made reports. We made annual reports, and those reports, I think, educated many people on how diverse that industry was and what it looked like. We had an interim program of inspections. We thought about carefully and seriously what we should be looking at for an auditor that was not receiving customer funds, but was simply advising the customer and the clearinghouse and a clearing firm on transactions. We had a different set of facts involving firms that did receive client funds, but promptly transmitted them overnight, as the Exchange Act requires, to a registered depository, and that, of course, was the key to the fault lines, the differences that different firms in this industry had. The firms that were full service, major banking institutions, affiliates, and had audits, had been part of a major institution's reporting system. Those audits tended to be the better audits. The audits that were the most questionable tended to be firms that were leaving, in some cases, the business. Audit firms leaving the business, or brokerage firms leaving the business. This was a time of rapid consolidation in the brokerage industry that had been going on for some time. So real questions existed as to whether there should be exemptions. We never resolved that issue. It became difficult to look at where an exemption should be granted. There were people who thought if you were, quote, mere introducing broker, a finder, you should not have to comply with any of the audit requirements. It's very difficult to justify that in light of what was seen as going on in the industry. Independence problems were a problem for the auditors of small brokerage houses who often require the auditor to help prepare the books. the best result in that case did not have the clarity that the transparency release or the audit report model or any of the other rules that we adopted did. So we never got around to promulgating a final set of audit inspection standards. We did not want to do harm. We did want to enforce the law and uphold the law. We did that when we saw enforcement issues, independence issues in the inspections of these firms, and we inspected a large number of firms. We inspected freely. We got the resources to do the inspections in our budget. And when we found those problems, we referred them.
It had been a little bit of a Wild West.
Yes. Of course, Madoff's problem was that his brother-in-law was the auditor and was in on the fraud. So deliberate fraud connived in by the auditor is a different order of problem. But the SE, if you have to undergo a PCAOB inspection, you should not be engaging in practices that enable the audit client or the broker dealer to engage in fraud. If you're not registered, or if you're not conducting an adequate audit, you will be in trouble. You will hear from the PCAOB.
And that's in fact what happened, very much. You were very interested in improving auditor communication with audit committees. Why was that one of your priorities?
I had seen that so clearly in practice. In the FCPA, the Foreign Corrupt Practices Act area, the breakdown in derivative accounting at Freddie Mac, so many of these areas which resulted in large-scale, costly problems for corporations and the ruin of careers by legal consequence. So many of these had to do with inadequate communication and inadequate follow-up in the boardroom. When I came on, the standard AS18, I think it was then, was well along, and it was a good standard. It was the first one we were able to adopt while I was there, but it seemed to me to be absolutely spot on for something that would in fact improve the role of the auditor and the visibility of the auditor where he needed to be visible, which is in the boardroom. It also was a basic start on the audit reporting model and CAMS. The audit firms, of course, being large, the major firms, the four major firms, large political organizations, present their senior management with political challenges. It seemed to me that it was important for the PCAOB to be making clear to the rank and file of these firms that when management says you've got to get on board with standards such as AS18, that there was a reason for that they meant it, and that it was in fact true that management was not simply speaking, giving voice to a principle that it didn't need to support, that in fact we were going to be pushing hard for management to show that they were working to make the audit and the firm top to bottom a place of higher audit quality. AS18 was an important part of that. Remains an important part of it. We've seen examples. We still see examples in which clearly in the Wall Street Journal and the Financial Times around the world, the communication has not been what it should be, and it's broken down.
Another one of your big pushes was the creation of the PCAOB Center for Economic Analysis. So tell me what was behind that effort.
Uh, a bias, a personal bias toward what the academy can offer the real world. I was not an economist, did not study economics, but in the study of history, the history of the 18th century, of the 19th century in Britain and in the 18th century in much of Europe, you could see how important political economy had been to what I would call progress. The cost-benefit rules and the interest of Congress in cost-benefit analysis was not going to go away. And in fact, I remember a discussion that David Becker and I had when he was general counsel down at SMU, when the question was mooted seriously: was the focus on cost-benefit analysis going to bring meaningful and useful financial services regulation to a halt? David and I, neither one of us believed that it would, but there was the question was, why not? What did it mean to say that you had to have economic analysis? And it was clear that the courts were taking a harder look at this. They were not so persuaded. They were not persuaded that, in fact, what the administrative agencies were doing in that regard amounted to the serious analysis that should happen. I had met through the contacts with Gordon Seymour and Sam Ross and Charlie Niemeyer, other people who had been so valuable on this. I had met Christian Leutz out at the University of Chicago and some of the other people in this area. And we went out there, and I had pulled some years earlier a book called Saving Capitalism from the Capitalists by a young Turk named Luigi Zingales. And I hadn't read it, of course. I had shelved it. And suddenly my counsel, Sam Ross, said, you need to read this. And so I pulled it and read it. And it was a wonderful thing to have in your hand, something that was telling you where you should go with the programs of the PCAOB. So we went out, we met Luigi, and he turned out to be a great find for us. And he became the founding director. And eventually he and Christian and others recruited people for us as fellows. One of the most recent, Preeti Chowdhury, is now coming east again, having been a distinguished professor in Arizona. We have others who are in academic positions now, having been in the center, who have written me notes. It's the greatest source of satisfaction that I have had to have the notes and the wishes, the well wishes, and to see where some of the alumni of the Center for Economic Analysis have ended up. And many of them are now in very important faculty positions. But after working with this for a while, we eventually got to the Office of Economic and Risk Analysis. And it is a full-fledged office in the board. It has fellows and permanent staff. And if you go back and look at the adopting releases and the proposing releases for the audit reporting model, the transparency release, disclosure by the auditors of how long they have been the auditors in the audit reporting model, disclosure of the other firms in the other participating firms. If you go back and look at those releases, you can see the maturation of the economic thought that goes into it. You can see an increase in the level of, I would say, the level of scholarly sophistication and validation of the things that the administrative body, that the organization is actually considering and should be considering in the area of adopting auditing standards. So I think the SEC was a great help to us, by the way, in having and getting this started. Their office of the Office of Economic Analysis there was useful to it. Was very helpful to us and useful. They worked hard on our behalf in helping us get started. We've done this in financial services regulation. So, why not in other areas? I mean, it's clearly when you have when we started this process, people looked at the Fed and they said, well, the Fed has this kind of economic analysis. That's why at one point people were suggesting that the SEC should be more like the Fed, maybe part of the Fed. The fact of the matter is that we're in an era now in which I don't think financial services regulations, the Treasury, the Fed, I don't want to irritate members of the Treasury or members of the Fed here. There are other organizations, I'm sure, the FDIC, who have many, many talented economists, but it is a fact that I think we have integrated economic analysis in the work of audit regulation, audit oversight, and federal securities regulation.
And it's proved very beneficial.
Yes.
You also made a very big effort to an outreach to your foreign counterparts, foreign regulators. In 2011, you were named Statesman of the Year by the Foreign Policy Association. So why was it so important to you to have this foreign outreach?
Well, I think I owe the Foreign Policy Association to Paul Volcker, who became a great friend and was a great resource and a strong support for the PCAOB. But we had begun, as I said earlier, to see how much of the audit resided abroad. Originally, the PCAOB had good introit, good access into European audits. The directive, Article 6, the Article 6 directive, I think it is, of the EU, changed that. We were not allowed to go abroad until there was a determination of adequacy. We determined, and again, by 2013, through this effort you have described of reaching out to regulators and including the EU Commissioner, Michel Barnier, we received a 6-year extension of the adequacy determination. And that really gave us the ability to move faster in getting access to foreign audits. And we brought European and Asian regulators here. So it was very much a two-way street. Europe, South America, much of Asia, China, of course, was the big exception and remains the big exception. And I think part of what we were doing, we were in fact making China an outlier in this area of inspections, of in-country inspections, in which both we and the foreign regulator would go in and conduct an inspection, they doing the work that they could do. We had enjoyed always very close relationships with Canada and had begun to rely on the Canadian CPAB, Canadian Public Accounting Board, Auditing Board, for parts of the inspection. We had similarly close relationships with the UK. Those resumed when we got the audit, the adequacy determination. France, we worked hard. We got good access there. We have had great relations with France, and the same with Germany. So we then moved. Spain, Italy, and the other parts of the EU became accustomed to seeing us. Japan, we had always had close relations with the Japanese regulator, and continued to do that. Continued to enjoy that. So in fact, this was the continuation of something that had begun well before I got there. And we were fortunate that we were able to get it to move it farther and faster. By the time I left, we were inspecting in 30 countries, and we're over 90 firms. And frankly, I think the transparency release and the identification of the foreign participants in the audit made that entire process more critical.
You really conducted a Herculean effort to get into China and to get an agreement to see the audit work papers of Chinese firms. And tell us that story.
We had the SEC, by the way, had done a lot of work. While I was general counsel, we went over to China. We brought our ethics rules to the CSRC, the China Securities Regulatory Commission, and the office, the work of the Office of International Affairs that I had known and had worked closely with Michael Mann and the originators there for in the Breeden Commission. That was something of a pattern. That we had that experience to follow in all of these dealings with foreign regulators, and we had a basis for dealing with the Chinese. We had some knowledge of what they did. The Chinese audit profession was young, still is, and is regulated by the CSRC. So it seemed that we should be able to do this. Sovereignty and issues of territoriality were raised, and we eventually, through the hard work of some very brilliant people, young lawyer named Alan Murray, who started out in enforcement and then moved over to the international side, and some other people, got us into China to be able to do some of that work. And in the report to President Trump by Jay Clayton and by Mr. Mnuchin, there's a letter from the current PCAOB chairman, Bill Dunkey, that describes in detail that how this work has gone forward and how it has been frustrated by the Chinese. And the problem with China has always been that you didn't know how far the people you were dealing with could go. Beginning with the CSRC and then moving on through my chairmanship, we would succeed in establishing good working relationships with individual officials at the CSRC, and that certainly was true in the strategic and economic dialogue, of which there were two while I was chairman. We went to the economic side of that twice. We seem to be moving forward. We did, in fact, get a pilot program. The pilot program was intended to allow us to inspect a Beijing-based accounting affiliate of a U.S. firm. We did that. It was to lead to a subsequent inspection of the Hong Kong-based affiliate of a major firm. Shut down. Did not go forward. And it's always with China, there's a step forward and two steps back. And that was very much our experience. We would be dealing with people who understood, because they had U.S. Wall Street and banking and regulatory experience, who understood what we were trying to accomplish. That we had to sell people in China on the idea that we were not looking at the internal documents of state-owned corporations that were in in the defense business that we were just looking at what the auditors had already seen. That in fact we were just checking the checkers in this sense to determine whether or not they had looked at anything, and what they had looked at, and what they might have asked for that they didn't look at. All of this gets to be extremely techy when you're dealing with with our own Western system. When you're dealing with the Chinese, it becomes, and only Mandarin can be spoken in a meeting, it becomes very difficult. But I think eventually the Chinese simply abandoned a process that would have enabled them to say to the last administration, to the Trump administration, look what we're doing with your audit regulator. They abandoned that at precisely the time when it might have been useful to them, but who are we to say what they might see as useful to them? The fact is, as the letter from the PCAOB to the administration shows, they have been very difficult to deal with, and you never know whether, if you have made progress on an MOU on enforcement or progress on a pilot program on inspections, you never know whether or not it will be implemented or can be. And this is a problem of dealing with non-transparent authoritarian regimes.
Yes. You were a Rhodes Scholar and you read history at Oxford, and you have said that Oxford was hard to shake off. My history lessons traveled with me. And your speeches are sprinkled with the most interesting references to Napoleonic Code and conquistadors and the Dutch West Indies Company and other early adventurers who are trying to finance high-risk trading operations across wide oceans. So I wanted to know, did you engage in this history of the early corporation as part of your studies, or did you get involved as a young securities lawyer? And you certainly did use it as you wrapped up your career at the PCAOB, didn't you? Well,
I wish that I could claim to have gone back and found each of those references for my speeches on my own, but I did not. I had a wonderful speechwriter. But the interest in the economic history of Europe was at Oxford. That's where I encountered intellectually R.H. Tawney and so many people who were important in the early 20th century in thinking about who we were and what our economy was. And that's what I meant, that it carries with you. I think my interest in going to law school came from that. I had at Harvard, in my brief encounter with a PhD program, I had gotten into the Encumbered Estates Act, which is a very arcane area. I do not intend to talk at length about that here, except to say that it is one of several examples in which the British Crown in Ireland tried to do the right thing and went badly wrong. You can see in history so many examples of where central planning or the use of economic theory goes wrong. That it does give you, I think, some skepticism, and it builds in some sense of restraint in what can be accomplished. And that, all I can say is I found it comforting at times that the problems we were having, such as dealing with a fractionized brokerage industry in which Bernard Madoff had prospered, that these were not problems that people hadn't encountered before. That there was nothing unusual about the fact that in a complicated economic society, you had to deal with very technical, nitty-gritty issues like this, and without clear answers.
It was during your tenure at the PCAOB that the first Part 2 inspection report was released, and that's the inspection report for an annually inspected firm. who did not remediate significant quality control concerns. So that was during your tenure. It was the part two of Deloitte's 2008, and it was released, within the first year that you were at the PCAOB. Describe that kind of big event and how you prepared for it and what the ramifications of it were.
It had been a source of great concern to the board that they couldn't get this done without facing a very long and protracted litigation. And it is part of the problem of the statute that delay is at times built in. We'll talk more about this before we adjourn, but the fact is, delay is not in the interest of serving the purposes of the Sarbanes-Oxley Act. Delay inhibits disclosure and reaction time. It inhibits the advice that firms need and the action they need to take. So the board had been working with this, and I think they were close. We hit upon the idea that maybe if they were not the only firm to go forward, that the existing quality control issues in the other major firms could be handled as well. And by sort of working through it, working with the firm heads, we hit on something of a solution, and that is that the firms, all of them, the other firms would agree that they would allow their reports to come out if we would allow them to attach a letter that says we take audit quality very seriously, and we're going to do something about this. And I think that was something of a break in the ice. It was in part coincident with changes in firm leadership. And I think as I said before, we wanted to make the firms sure that we had, that we were serious and that they had to work with the staff. They had to honor what they knew to be legitimate objections by the staff, legitimate findings. All of this was accumulating in the mix, along with the possibility that we might order the firms to change the issuers to change auditors every 10 years, along with the fact that we might require audit partners, engagement partners, personally to sign the audit report. So all of this was going forward. I think once they knew that we were going to do some things, then some of these things became less sure as a fire break for them. I mean, they began to see that with Sarbanes-Oxley having been adopted because of Enron, WorldCom, and Delphi, and then having come through the 2008 financial collapse, I think there was a proper sense that the ice was a bit thin and that we needed a new tone in dealing with the PCAOB. That's what they told us. They said to us in so many ways, we're not going to have our auditors requiring us to defend to the bitter end all of their objections to all of your findings. And they after trying, I think, what they thought they could effectively try to blunt this, I think they came to the conclusion that, look, it's better not to appeal it, not to prolong it, It's better to convince the public that this is a problem that we have surmounted, that we're getting beyond this stage. It's what they said, and it's what they did. The reports issued, the Deloitte report issued, followed promptly by 3 other Part 2 reports on major audit firms, with the caveat that each of the firms was saying, yes, we're agreeing that this can become public, but we do not intend to allow the public to think that we're not attentive to audit quality. We will be attending to audit quality. It was a process.
Yes. You also fought against the effort to keep disciplinary proceedings confidential, which is, of course, one of the that was within the statute. That was something you really didn't have control over, but you fought against that. To talk again, why?
I think first, the opinion was very strong at the board that we did not really have the authority to release our file charges and to release other information that we had. I had, and before I came to the board, there had been a very strong speech by our division, our enforcement director, Claudius Modesti, about the fact that this was an inhibitor, that the firms shouldn't object to this. It is part of the statute, and I had the view when I came that I was not sure how much of an inhibitor it was, but when I came, there were some cases that I became aware of, I learned about, in which firms had litigated for years, raced out and gobbled up as many other engagements as they could and performed the same bad audit on those engagements. Some firms were telling issuer clients, don't worry about the PCAOB, don't worry about these charges, we'll bottle those up, the public will never hear about them. So there were 2 things about it. One, it was the agent of delay that I've spoken about that really inhibits the process of making audit better. But the second thing was that I, as a lawyer who had been advising clients, issuers, and at times auditors, it did not sit well that the people who were supposed to be cautioning issuers about relations with their auditors and what they should worry about in dealing with their auditors, or auditors in what they should be doing or not doing, it did not sit well that all of these advisors would be ignorant of what some audit firms had done and were doing. It seemed to me that charges as filed should be public. I still believe it. I think that the settlement process will be more efficient. It will not be undercut or rendered meaningless. I think the firms would be benefited by getting these cases behind them instead of having a partner or a manager protract litigation for a long period of time. Sometimes I think at the firm's expense. So I think it would be better all around if when the PCAOB decided that an auditor should be sued, that they could divulge that they could make a litigation release about that, just the way the SEC does with respect to their lawsuits and every other litigating federal agency, the FDIC, for example. The speed with which things settle may reflect some progress in this area. The commission, or the PCAOB, this last couple of weeks, has announced the sanction against an auditor, Brazilian auditor, being unregistered and not performing the work they should do. The division has been very, I think, very effective in taking the enforcement message to jurisdictions which may not be as respectful of honest financial reporting as our own. And so there may be, I think, cultural differences have made a difference in the way that some jurisdictions have viewed the audit problem with China.
On your watch, the PCAOB turned 10, and there are some who feel that you really put it on the ecosystem made the PCAOB a player in the ecosystem of financial regulation. And do you think you succeeded there? And if so, how did you do that?
Well, anyone who said that is being very kind. The PCAOB, I was told by Mark Olson, the late Mark Olson, before I joined it, that that there was a wonderful staff and a great esprit de corps among the staff. I found that to be true. It's a great organization. I feel privileged to have been able to be its chairman. As I said, at the time I came, I felt it was paramount that the firms knew that we were going to push them to improve, that we wanted them, that they had better respect the PCAOB and its auditors, that it wouldn't do for them to complain to others that our findings were merely technical lapses and that, in fact, they were not fair. All of that was, in fact, pushed back and aside. And I think with good results for the firms as well as for public confidence in the audit and the PCAOB, I wanted the PCAOB to be respected. I wanted the staff to be respected, and I wanted a sense of mission. And I think if you persuade the staff that is your lodestar, you're going to be all right. Your organization is going to perform well if you have told them that they are not to eschew risk, that there are times when risk is warranted, and that if risk is well taken, if it's taken for the proper purpose and with proper consideration of the risk, if it doesn't turn out well, you will back them up. So I think the organization did wonderful things while I was there, and whether it's standard setting or inspections or enforcement or the or economic analysis, whatever you're looking at, I think these were the result of a staff that knew that they were being encouraged to go out and think of what they could do to make it a better place and to make it a more respected organization. And I don't think there's anything unusual about that, patented.
There's always been a natural tension with the SEC, who has, of course, the oversight authority over the PCAOB. What was your experience?
Yes, there is tension. And I refer to it as creative tension. The statute establishes it as oversight authority. The extent to which the meaning of those provisions and the extent to which they're employed, I think, are a matter and should be a matter of some interpretation, some thought, some review from time to time. Early on, I think the firms liked to go immediately to the chief accountant's office and to say, you'll never guess what they're doing at the PCAOB, and the inspection findings are mere trivia, and these are not good. I think that's a practice that you can expect. I mean, it wouldn't surprise anyone that they would try to go over your head if you were doing things they didn't like, and they did. But I was there for 7 years. I was not removed. I was there actually for 3 years after my term expired. I think the firms were no less vociferous in the last 3 years than they were in the first three about the fact that they wanted a different kind of PCAOB. But I thought our relations with the SEC were always correct, and we enjoyed always good treatment in the budget hearings. The test really of how things sit between the PCAOB and the SEC can be read in the budget hearings. And the chairman of the PCAOB sits there with the chief accountant and with the chief of operations of the SEC, and reports to the commission and talks to them and receives their questions. And those were always, I think, those were good meetings. They were well attended. They were thoughtful. I think that the PCAOB is well served by being able to sit in front of the commission with the chief accountant and the chief administrative officer and talk about what has happened over the last year and what they expect to have happen. There are questions that come from the chair and the commissioners about what they want the PCAOB to do, or to do more, to do faster. Are we going to see a permanent set of standards on inspection schedule of broker dealers, for example, came up from time to time. But it gives the PCAOB a chance to discuss with the commissioners in front of the chief accountant and with everyone there how we see things. And I thought those were wonderful meetings. I believe that it would be well served for the commission not to involve the professional accounting fellows of the SEC in the actual substantive work of developing the auditing standards that eventually will be applied to the professional accounting fellows when they go back to the profession. That's something that could be done. It would be easily done. I think the more the PCAOB is reporting to the chief administrative officer of the SEC and directly to the commission, the better the commission is served, and frankly, the better it is for the chief accountant and the performance of their highly specialized mission, which is to advise the commission on novel questions of accounting disclosure and to tell the public about that. So there's no doubt the oversight is there. I do not think the PCAOB would want to say we have no responsibility to the commission to keep them informed fully. And it was always in the budget hearings, in the budget process, which is a very exacting process. It was always useful to know that we had a lot of discussions with the SEC's staff before we went before the commission.
What do you think is your legacy at the PCAOB?
I have, with age and I hope experience, become mistrustful of legacy. The one can never know. I do think it is a mistake if you're in the position of leadership of an organization to have your personal legacy become a determining factor in your decisional process. You have to listen to too many people. You've got to reconcile a lot of points of view. You have to keep your, I think, mind focused on what is in the public interest and what's best for that organization at that time in performing its mission. And maybe you don't have a legacy. I mean, sometimes events move so fast and things change so completely that you simply fade from memory. The SEC Historical Association is here because I think many of the people who worked so hard and so valiantly over years at the SEC realize that the rapid change, the transformation of our capital markets and everything that's going on will mean that at some point, their little preoccupations will seem quaint and unimportant. And in fact, some of the things they did will seem to be mere footnotes. So I'm not a big believer that one can know a legacy or one should be spending much time thinking about it.
Well, all right, Mr. Chairman, this was delightful. Thank you so much for sharing all of your insight with us.
I hope it was not too verbose. The problem with former chairman is the verbosity bias. Thank you. Yeah.